Let's start. It is well settled proposition of law that a party to an agreement cannot refuse to perform his obligations under an agreement merely because their performance has become more onerous. As pointed out by the learned counsel for the claimant, the doctrine of frustration is an exception to the sanctity, inviolability, and enforceability of contract. The law accepts parties to abide by the bargain which they have struck unless they are exonerated from performing their obligations by supervening events of an extreme and unexpected character over which they had no control. The concept of frustration of contract has varied from country to country and from age to age, when supervening events over which the parties had no control have led to a situation where the lessee of a piece of land given on lease for construction of a hotel is required to pay more than the actual turnover of the hotel itself as itself consideration for the lease, which is over and above the lease rent stipulated in the lease deed. It is just and reasonable to conclude that such an agreement has become frustrated. The development of the concept of frustration of contract under the common law is no doubt interesting and educative, but it is unnecessary to dwell at length on any foreign authorities, as in my considered opinion, the judgment of the Honorable Supreme Court of India reported in AIR 1954 SC 44 is sufficient for the purpose in hand. Courts in India have applied the principle of commercial impossibility in appropriate cases. Illustration can be found in within bracket small I Sushila Devi versus Horishi within bracket 1971 to SCC weekly notes. There can be no doubt that the principles of res judicata are applicable to arbitration proceedings. However, the claimant is relying on events that occurred subsequent to the passing of the award dated 17th May 2008 by Mr. Justice within bracket retired K.S. Sidhu, and hence the earlier arbitration between the parties cannot operate as a bar to the present arbitration panel. To conclude, on the basis of the evidence laid before me, I have no difficulty in holding that the agreement between the parties that the claimant would pay minimum granted amount as stipulated in Schedule A to the supplemental agreement dated 7 February 1996 become impossible of performance in a commercial sense on account of the frustrating events that occurred during the second half of 2008. This, of course, does not mean that the claimant has ceased to be bound by the retirement of clause 3 of the lease deed to pay an additional amount as a minimum granted amount which may be mutually agreed upon, and following such mutual agreement as determined by the chairman of the respondent. I agree with the submission of the learned counsel for the claimant that there is nothing in clause 3 of the lease deed to suggest that such mutual agreement or determination by the chairman of the respondent is a one-time act or event, since I am holding that the supplemental agreement dated 7 February 1996 has become impossible of performance from June 2008 on account of two supervening events over which the parties had no control. It will now be necessary for them to arrive at mutually acceptable figures, following which the chairman of the respondent will have to determine what those minimum granted amount should be in the absence of a specific arbitration agreement between the parties. To the effect, this tribunal remains from expressing any opinion on what those figures should be. However, I am recording the fact that the learned counsel for the claimant stated before me that the claimant is not challenging the obligations of the claimant to pay 7.5% of the gross turnover of the hotel as stipulated in clause 1 of the supplemental agreement dated 7 February 1996, whatever be that amount. Submissions on behalf of the petitioner 7.1. The doctrine of frustration as enacted in section 56 of the Contract Act has no application to leases. Reliance is placed on Raja Dhruv Chand versus Raja Har Mohinder Singh EIR 1968 SC 1024. Even assuming section 56 applies to leases, it cannot be invoked in case of commercial hardship. Frustration cannot be used as device to avoid a bad bargain. The contract between parties was for a period of 30 years, and it was but natural and foreseeable by both the parties that there would be various economic turmoils over the period. As long as 30 years, principles of frustration is not applicable when the event is foreseeable but not foreseen. The lease deed and the supplementary agreement within the both entered on the same date clearly provided that the respondent is liable to pay the royalty within bracket MGA. There is no liberty reserved to the courts to absorb a part liability to perform his part of the contract merely because on account of certain turn of events the performance of the contract may become onerous. Stop. Thank you. Jai Hind. Jai Mera Bharat.